Welcome back to the third session, the Ultimate Workshop for Business Owners, 2014 Tax, Succession, and Estate Planning. This is the estate planning section. We're going to be taping this program. We're going to be putting it on YouTube so that some of you may be out there watching this then on YouTube, and you're going to say, gee, we're referring to all these materials, and I don't have any materials. Well, we would encourage you to contact me, Bill Hesch, or Amy Pennekamp at our office, Hesch Law. The phone number is 513-731-6601. So with that, I think we're going to get started. Amy's going to start out this first session here, and I'll be wrapping it up, so I'm going to turn the program over to her. Thank you.
Hi, I'm Amy Pennekamp. I've been working with Bill for almost 10 years now. And I thought, just in keeping with my Valentine's Day theme that I started, we'd have a little raffle at the end here. We'll raffle off a box of chocolates. So if everybody would put their name on one of the cards, Kurt's going to go around and pick it up. You can either enjoy this yourself, or this can be a last-minute Valentine's Day gift if you forget to get something for your loved one. We got to have something a little exciting if we're going to talk about estate planning. But what I'm going to do is I'm going to go through kind of a basic overview of estate planning, and then kind of go through some problem areas in estate planning. And then I'm going to finish off my topic with Medicaid planning, which is a little bit different. But I'm going to start with estate planning. And really, estate planning it comes down to who gets what and when. If you die or become disabled, who's going to be in charge of your estate? Who's going to be in charge of making your financial and healthcare decisions if you're living but you became sick and disabled? So we have in our packet of materials an estate planning self-assessment guide that we would encourage you to complete later on. And basically, it'll kind of help you assess where you are with your estate plan. Do you have the documents in place that we would recommend? Are there some things that you should consider? Do you need to meet with your advisors to possibly update your estate plan, or perhaps you haven't even done one and you should take a look at it? So I would encourage you to go through the self-assessment guide to see where you are at this point in your life. But basically, I'm going to start with the basic documents, the last will and testament. And the last will and testament is, if you die, who is going to receive your property? And kind of going in line with that, one of the problem areas I'm going to go ahead and talk about, and that's on page 5, is oftentimes people say to me, "Oh, I don't need a will. Everything will." I don't know. People seem to not know what would happen if you don't have a will. And your state of residence has a will in place for you if you don't have a will. And you may not like what they provide for you. So that would be a reason why I would encourage everybody to think about whether or not you should do a will. And one important distinction is, in the state of Kentucky, if you do not have a will, then 50% of your estate, assuming you have no beneficiary designations, 50% of your estate would go to your spouse and 50% goes to your children. And most people, when they hear that, if your spouse is the natural parent of your children, most people would not want that. Most people don't want that. All the states have laws to try and protect that if there's a blended family, a child from another relationship, that child wouldn't be excluded. So Ohio has very detailed rules about what happens if you have a spouse and they're the parent of all the children, one of the children, more than one of the children. So they kind of break it down. But Kentucky doesn't do that. They just do a straight 50% to the children, 50% to the spouse. So if you do have a child from a prior relationship, that would protect that child so that they weren't excluded. However, that might not be what you would want if your spouse is the natural parent of all of your children. So the will also, another reason why you would want to have a will is to name your guardian for minor children. What happens is, if you pass away, then, if something happened to you and your spouse or the other parent, the probate court will appoint a guardian for your children. If you have a will that designates a guardian, as long as that person is a suitable individual, then most likely the court is going to defer to your selection, and that person will be appointed the guardian. But if you have not named anybody, then it's the court's job to try and figure out who would be the best person for your children to go live with. And kind of one common problem would be maybe the family members would be the ones that come forward to try and be appointed your guardian, but maybe your family members live out of state, and you would have preferred that your children go to live with a close friend who lives in your, maybe it's close by, so that the children's lives are not, so that they can be as close to how they were before in terms of going to the same school, staying with the same friends. If you don't have that designated, if a family member comes forward, you have a family member coming forward, a friend coming forward, the court's going to have to figure out who would be the best person to raise your children, and you can have a mess. And unfortunately, I have seen it where a lot of times you have, unfortunately, a deadbeat parent or a family member coming forward because they know that this child's going to be receiving Social Security, and the reality is there's a lot of people out there that they'd be willing to be the guardian because they need to rely on that child's Social Security. And so it's very important to have the will so that you can designate who you would want the guardian of your children to be. The next document would be powers of attorney. If you became sick or disabled, who is going to handle your finances? The power of attorney is the document that you would need so that somebody could go into the bank, get put on your account so that they could pay your bills. If you don't have a power of attorney and you became sick, then your family members, friends are going to have to go to the probate court and be appointed the guardian of your estate. The guardianship process through the probate court is a nightmare. The point of the probate court is they're there to protect your estate and to make sure that everything is being done properly. But it can also be an administrative burden for the family member because what happens is basically you have to put together a budget, a monthly budget of the individual's expenses. The probate court will approve the budget and that's it. That's the only thing you can spend money on. So, if you set forth, 5 people that need to be paid every month, utilities, and then you have an unexpected expense come up, you have to go back to the probate court, get approval to be able to pay that before you can even do it. And the guardian also has to account to the probate court every 2 years, and so they have to keep receipts, and it just can be a very costly experience. In Hamilton County, Ohio, the guardian has to have an attorney co-sign on all checks. So really the only people that win in the guardianship process are the attorneys because you basically have to have one, and it just can get very expensive. The power of attorney is an inexpensive document to have, and it really can make things so much easier. There's 2 types of powers of attorney. There's a power of attorney that takes effect immediately. So if you sign it, whoever you designate can handle your finances immediately. And then there's also what's called a springing power of attorney that only springs into action if 2 doctors have certified in writing that you're disabled. So your agent cannot act under it unless 2 doctors have certified in writing that you're disabled. Kind of depends where you are in your life. Sometimes if we have, couples that have been married for a long time, we just go ahead and do a durable power of attorney. A lot of times you already have joint accounts anyway, so you trust each other, and so we just do a regular power of attorney. This can also be good if you have one spouse that travels a lot, and for convenience purposes, then the spouse could sign on their behalf. If you were going to sell property, or you had to sell a car, the power of attorney would allow that spouse to handle all those things while the other spouse is traveling. But oftentimes people feel like you don't really need it unless you're disabled, especially younger individuals. So then we just generally recommend a springing power of attorney, that the person would only be able to handle your finances if two doctors have certified in writing that you're disabled, because it is a powerful document. Your power of attorney can go into the bank and they could withdraw all the money from your account. So it is something that you only do with somebody that you trust. And so it really comes down to a personal situation as to whether you're going to have a durable power of attorney or if you only want to have a springing power of attorney. The other important documents would be healthcare power of attorney and living will. And in Ohio, they're 2 separate documents. In Kentucky, they're 1 document. but who's going to make your medical decisions if you're unable to do so? Again, if you don't have these documents in place, a family member, friend has to go to the probate court, be appointed your guardian to be able to make your medical decisions. Again, it's just an administrative nightmare for this person. And because we're in Kentucky, I'll just kind of focus on the Kentucky form for right now. But basically, the Kentucky has a healthcare surrogate designation and living will form. And in the form, you would designate somebody to make your medical decisions. So if at any time you couldn't make a medical decision, who's going to do that? Maybe you're temporarily unconscious and somebody has to sign for surgery. Who would that person be? But then the Kentucky form also allows you to designate if you were terminal or permanently unconscious. Do you want to allow that person to make end-of-life decisions for you, or are you going to do that yourself right now? Because the form allows you to designate whether or not you want medical treatment withheld or withdrawn, whether or not you want a feeding tube withdrawn or withheld. And so either you get to make those decisions right now, or you can allow the family member to make those decisions for you. We've been told by doctors, nurses, that it can be very hard for family members to have to make those decisions because they feel like they're killing the family member because they have to sign off on the last orders. So if you know that you don't want life support, you wouldn't want a feeding tube, then we generally recommend that you would go ahead and make those decisions now and you would designate it in the living will. But sometimes people are unsure, or sometimes if you have like a young couple, maybe they want to allow the spouse to kind of survey the circumstances and make that decision. And so you can go either way on that. And again, that kind of comes down to a personal preference and kind of relationship you have with family members. I had a client tell me we did documents for his mother, and he said, "We don't need a living will. We'll be able to make the decision. We'll make the decision. We're a strong family. We'll make that decision." And when his mother died, and he came to see me a month later, he said to me, actually that was a lot harder than I thought it was going to be. It was awful. Like it was a really hard decision to make. And so I think that, those situations, if you've never been in them before, it's just very hard to say that you would be able to make those decisions. So those are the basic estate planning documents. Bill's going to go through why you may want to consider a trust, which would be the next level in estate planning. But one thing I was going to do, if we want to turn to page 5, is I'm going to go through kind of the top mistakes in estate plans. And we already covered the first one, that if you don't have a will, the state has a will for you, and you may not like it. One other thing I was going to point out about there is stepchildren, that if you were going to include stepchildren, they would need to be specifically provided for. Otherwise, under state law, they would not be included on the first level. Every once in a while, I have a client tell me that it just kind of comes up that they've actually been raising a child their whole life, and that's the only parent that this child's ever known, but they legally never adopted them. And so that's why it would be very important then that you have a will and that child is designated by name, because otherwise if you just said to my children, then they would be excluded. And we already talked about the number 2 of needing a guardian, naming a guardian in your will. The third one would be, so maybe you do have a will, or maybe you even have a trust. So you've done all this great estate planning and you think that your estate's going to pass to the people that you designated in your will, your trust, but you have all these other assets that have beneficiary designations. So you have a life insurance policy that has a beneficiary designated. You have a 401k IRA with beneficiaries designated, and they don't match your estate plan. I see this a lot with younger people. Like sometimes younger people have a parent listed. They got a life insurance policy through work, and they designated their parent, and now they're married with 2 children, and they have an estate plan that says everything goes to the spouse, everything then goes to the children. The beneficiary designation will trump the will, the trust, and so it's very important that you take a look at your beneficiary designations to make sure they're consistent with your overall plan. I have a good friend who works at Fidelity, And she tells me she has countless times where people call and they cannot tell you who the beneficiary is. They can just tell you that you're not the beneficiary, where people did not take an ex-spouse off of an IRA, and one time she had a second spouse calling and thought they were the beneficiary, but as it turns out the first spouse was the beneficiary because the participant never updated the beneficiary designation on your IRA. So, and that was one of the examples I gave too, is for life insurance. If you have people going through divorce and you have a spouse listed as the beneficiary, but your trust says everything's going to go to your 3 children, the beneficiary designation is going to trump. So it's just very important that unintended beneficiaries don't walk away with your assets. Another problem is, again, you've done the proper estate planning. You have you even have a trust set up, but you haven't. You you sign your trust and you think everything's fine. You've done everything you need to do, but you haven't actually followed through then to update your beneficiary designations to your trust or retitled ownership of your assets, real estate, bank accounts, that you have not put them into the trust. Then what happens is, if something happens to you, although your will provides that everything goes into your trust, now you have to go through probate to get the assets into the trust. And a lot of times when people come to see us, that's one of their goals, is to avoid probate, because they've heard all these horror stories about probate. And probate in itself is not a bad thing. The probate court's role is to oversee your estate to make sure that the intended beneficiaries receive the assets. The problem with probate is that there's administrative delays, because your executor has to go to the probate court and get appointed. The assets are frozen until that person's appointed. That could take a few weeks. Always like a big problem is when you have people that they got to pay funeral expenses, but they don't have any access to the assets because they were all in the decedent's individual name. And now you have this holdup. We just had somebody come in yesterday that she had to personally pay for a funeral, put it on a credit card, and she was kind of upset because she's paying interest on this credit card because she didn't have access to funds to be able to pay this funeral. So if everything is in your trust, then if something happens to the grantor of the trust, then the successor trustee immediately takes over, and then there's no delay. So basically the trustee, they can go into the bank with the death certificate, get updated on the account, and then they can continue writing checks out of the trust accounts, paying bills. So that's kind of one of the horror stories of probate, is there's this administrative delay. And then the other thing is the attorney fees that are involved with probate. And, it's a tedious process, and so when you have an attorney involved, there's just a lot of time that gets racked up preparing all the filings. And so when people say, well, I don't want to avoid the cost of probate because the government's going to take everything. It's not the government, it's just the attorneys. So, but people just don't know. So, so going back to the problem that, you spent all this money setting up a trust, but then you didn't fund it. So now not only did you spend all the money setting it up, now you're going to spend the money on the attorney to get everything into the trust. So that's why we really work with clients after we sign the documents to really make sure that your beneficiaries are updated, consistent with your estate plan, and that you have retitled assets into the name of the trust. Another problem would be 401k IRAs, and not making sure that you have checked on the beneficiaries, because with the 401ks and IRAs, traditional IRAs, these are tax-deferred accounts. And there's very special rules as to when somebody passes away, how that money has to be distributed to the beneficiaries. There's favorable rules for the surviving spouse, but it's very important that you take a look at your 401ks, IRAs with an advisor to make sure that there's not going to be any negative income tax consequences, because oftentimes this is kind of a problem, is if you have somebody that is unmarried, so there's no surviving spouse, and they also have not named any beneficiary, then the 401ks, IRAs have to pass through your estate. And there's a rule that basically says if there's no beneficiary, there's no spouse, those IRAs, 401ks have to be paid out over a 5-year period. So the beneficiary has to pay the income tax on this money over a 5-year period. If you have, and the rules are very specific and it's on a case-by-case basis, but if you had a benefit, in this scenario, let's say you had a beneficiary named, then the individual can do what's called an inherited IRA and take that money out over their life expectancy, so a longer period of time, and it can minimize the income taxes that are owed. I had a client who his brother passed away, and the mother was the beneficiary, but she predeceased everybody. So by default, my client, the brother, became the beneficiary. It was a $200,000 IRA that had to be paid out over 5 years. Well, by the time he got to us, it was already 2 years in, and he hadn't done anything. So he had to take this $200,000 out over 3 years. He and his wife were both still working, had pretty high incomes, and they were going to have to pay tax on this $200,000 over a 3-year period. It didn't give them much time to stretch out the income taxes that were owed. We did recommend that they maximize their own 401ks to try and minimize their income, but that's just one of the issues with 401ks, IRAs, that you have to be very careful about beneficiary designations, because if you don't, depending on how it flows, your beneficiary could be stuck with negative income tax consequences. And the last thing I was going to talk about is failing to organize your asset information or starting to have discussions with your children about your assets can leave family members, children, very overwhelmed and stressed out. I actually recently met somebody my age who unfortunately lost both of his parents in the past 2 years. And he and his brother are very overwhelmed because they were not privy to any of their parents' financial information. And so they have no idea where they're going to start. And I've just kind of tried to have some conversations with them just in the past couple of weeks, kind of helping them kind of maybe start thinking about how they want to get organized. But, they're 32 years old, and it's very, very stressful. And, there's a house that they're going through mom and dad's house, just starting to go through mom and dad's house to kind of start getting things organized. They have no idea what kind of bank accounts are there. They do know that their dad had an IRA, but they really have no idea what the rules are and what they have to do. And so I would encourage you to think about, some people just do not feel comfortable talking to their children about their assets. And I understand that. But if you're not willing to at least kind of start that conversation, at least you have all your paperwork organized in a central area so that if something happened to you, they would know that all of your estate documents, all your financial records, asset information is all in one drawer and they can find it. Because we also had a client where there were 2 grown children that really had never been involved in mom and dad's finances. And mom and dad did not keep things organized at all. And it's basically been a treasure hunt. Just kind of, oh, look, we found another asset. We didn't know that existed. And the records are so bad. So I think it is very important to have everything organized if you're not willing to, discuss it. But I think it is a good conversation to have, at least to a certain extent, so that, the children kind of know what needs to happen if something happens to mom and dad. And lastly, kind of going along with that is your funeral plans. We encourage people to pre-plan their funeral. I know not many people want to do that, but have you at least thought about what you would want, and have you written it down somewhere? Because if something happens to you, your family members are grieving, they're overwhelmed, and now they have to figure out what you would have wanted. And somebody recently asked me if I would be in charge of their funeral plans, and I said sure. And when they told me what they wanted, I was really kind of surprised. Like, I would have thought they wanted something else. So, it's very good to communicate that, because otherwise, whoever's making the decision is going to make the choices, and that may or may not be what you wanted. So I think those are kind of the top mistakes I was just going to go through. And we're going to kind of shift focus to Medicaid planning. And we'll go through this rather quickly. But Medicaid planning is, and maybe this would basically probably, for everybody in this room, if you think that you have a parent that might be having to go into a nursing home, and what's going to happen if they go into a nursing home? How much is it going to cost? Nursing homes, they can average, $75,000, $80,000. If you need skilled care, we have somebody that's in Northern Kentucky paying $100,000 right now because she suffered a stroke. She needs a lot of care. So it can be very costly, and people want to know, how are we going to pay for this? And so there's kind of this misunderstanding. People at first think that Medicare is going to cover the nursing home costs. And Medicare doesn't cover the nursing home costs. It only covers if you go from a hospital. It'll cover up to the first 100 days. But basically after that, you're looking at privately paying for a nursing home. And, like I said, at $75,000 to $100,000, not knowing how long a parent might be in the nursing home, it doesn't take much to start depleting assets. And so that's when, you're looking at Medicaid. Medicaid is the government program that would pay for nursing home care, but they don't pay for it until you're broke. So I basically kind of have a worksheet here of just kind of some things to go through. If you're in that, you might have a family member that could be close to going into a nursing home and identifying how much it's going to cost and will Medicaid be available. And the first thing would be to identify the individual's assets, because for Medicaid planning, it's very important to know what the assets are, the type of the assets, how they're titled, and the approximate values, because the Medicaid rules vary depending on the type of asset it is. If it's a house, who lives in the house, it's very, you have to just do it on a case-by-case basis. But if you were getting ready to go meet with an advisor, these are the things I would tell you to start with, is identifying the assets. Identifying potential nursing homes, considering the individual's needs and wishes. Nobody wants to go into a nursing home, but if you had to go into a nursing home, have you identified a couple choices that maybe your parent could live with if they had to go there? Do these nursing homes provide for the care that your family member needs? A lot of the Alzheimer's patients, you have to go to specific nursing homes that have locked facilities. It can be very difficult to find nursing homes that have Alzheimer's wings. What is the monthly cost of care at that facility? Do they have Medicaid beds? If we could get you to a point where you qualify for Medicaid, does this facility even accept Medicaid? And is there a wait list? In Kentucky, there is a very lengthy wait list for the Medicaid beds. And so it's generally better if you can get into a nursing home private pay first, because usually once they have you in as private pay, they're more willing to they'll try and get you into a Medicaid bed, as opposed to if you're just coming in on a Medicaid bed, there's a wait list and it can be very difficult. So kind of looking into answering those questions. And then how about the individual's monthly budget? What are their current living expenses right now? And what expenses would continue if they went into a nursing home? Because when you meet with an advisor to see if you can do any kind of Medicaid planning, you need to be able to put together the person's budget so we can kind of see what are they going to need in order to be able to do this planning. And then you have to know the Medicaid rules, which I'm not going to go into the rules right now because we're running short on time, but there are accountable resource tests where Medicaid looks at what your assets are and how much you have to spend down, and then also what is your monthly income, and that will have to go to the nursing home. So there are special rules to see if you qualify. And how soon will the person need nursing home care? Are we in an immediate situation, maybe within the next year, less than 5 years, more than 5 years? Because Medicaid has, and that's my last point, is the planning opportunities. People always say, well, I'll just give all my assets away and then I'll be broke and then I'll qualify. But Medicaid has a 5-year look-back rule that if you make any gifts to family members, it's deemed an improper transfer and it can disqualify you for Medicaid for a certain amount of time. And so in order to decide if any planning can be done, we kind of need to know where you are, where this person is in terms of how soon are they going to be needing nursing home care? Can they get through the 5-year rule? And usually it's early 70s, late 60s, 70s. Those usually people can get through the 5-year rule, that you can be more aggressive in your planning. But we often have people. We had somebody come to us at 90, 91. It's very hard to do planning with the 5-year rule at that point. But the planning opportunities will depend on the amount of assets, the health of the individual, their willingness to do any planning, and are they competent to do any kind of planning? Would they be able to transfer assets? And what the family relationship is, because in order to do some Medicaid planning, you're basically giving up control of your assets. You have to have a good relationship with whoever it is you're going to do this with, usually the children, or it wouldn't work. And then finally, there are a few planning strategies, and one is strategy. I'm just going to kind of go into those quickly for Medicaid planning. But one strategy is a care agreement that maybe you can't get by the 5-year rule. Nursing home care is going to be coming sooner, but you have family members that are taking care of the individual, and they're not being compensated. We can enter into a written care agreement where you actually pay the family member. Generally, $20 an hour is accepted in this area. That person would at least be compensated for taking care of the individual. You have to pay. It's subject to income taxes, but it's better if that's kind of a last ditch effort. That it's better to do something than nothing. Gifts and trust, where we actually gift away property, and this does involve advanced planning because, like I said, there's a 5-year rule for any transfers. But people that want to be more aggressive and try and make transfers to their children so that after 5 years those assets cannot be taken for Medicaid is a planning opportunity. Pre-planning funeral, paying all your household expenses is another way to legitimately spend down for the rules. And then finally, another technique is disinheriting the spouse, because with the Medicaid rules, if you leave everything to the spouse and then the surviving spouse would have to go into the nursing home, the rule is that surviving spouse has to spend down to $1,500. They basically have to have nothing left. So if we have two spouses and one, not knowing who could die first, there is some planning that can be done with a trust that you would disinherit your spouse so that at least, you split the assets in half. You've at least gotten half of the assets out to your children so that they wouldn't have to be spent down. And finally, the last two things, just some special Kentucky rules. Kentucky has a rule that if you have IRAs, 401ks, that they're exempt assets for Medicaid. They don't have to be cashed in. And that's kind of a difference between Ohio and Kentucky. Ohio does require that they be cashed in and spent on nursing home care. Kentucky only requires that you keep taking out your minimum distribution every year, and that has to be spent on nursing home care. So there are some advantages to living in Kentucky and qualifying for Medicaid, because basically if you had an individual that only had a 401k, that was all they had, it was $200,000, that person would immediately qualify for Medicaid, and that 401k could not be used for the nursing home, and they could pass that to their heirs, and there would be no Medicaid estate recovery. And also in Kentucky, if there is a surviving spouse, there is no Medicaid estate recovery. Basically, when the individual dies, Medicaid cannot come back on the surviving spouse to take any remaining assets that the spouse got to keep. But this is kind of a really brief overview, and I kind of really went fast because I want to save time for Bill to go through the reasons why you might need a trust. But the final thing I would just say is that the Medicaid planning is pretty complex, and I would just really encourage you to meet with an advisor if you have a family member that's possibly going to need to go in a nursing home, to just make sure you've positioned yourself if there's anything you can do to salvage assets. So at that, I'll let Bill finish up, and then we can take questions on this section, and then we'll have our little raffle.
All right, great job, Amy. And I did want to kind of go through the handout that we had so that you'll find that there was a Estate Planning Self-Assessment Guide is at the very top of the handout. This is a tool that if you answer the questions, it's intended to help you have a tool to work with your advisor. If you answer no on the questions there, it means that may be something you may want to talk to your advisor about. Okay? If you answer yes, you're doing good. If you answer on the trust section, though, if you answer yes, then the more yeses you have, then the more reasons you would have as to why you would need a trust in your estate plan. I think that what we've got in one of the handouts there was also the, you'll see that the 3 W's in estate planning that we had, that wasteful spending, wrong heirs, and worthless investments. Those are the top 3 problems we find. And we have a couple other handouts about here, the 5 problems, that those were the top 3, but we also have heirs that have drug and alcohol problems that you don't necessarily want them to inherit money outright. You want to use a trust, as well as if you want asset protection with creditors. It's another reason to use a trust in your estate plan. So trusts are very effective tools in estate planning, and that the outline here also identifies some of the other issues, particularly if you have a blended family. We're using trust in a blended family situation because you've got his kids, her kids. We actually have a situation yesterday. I mean, this happens every day. Yesterday, couple came in, his 2 children, he wants to disinherit. It's a blended family. Their 2 kids, they want to inherit. You know, he hasn't seen his kids in 7 years. Those things happen, and they're trying to structure things in a way. And one thing we talked about was the use of a trust to ensure that the assets are provided for the surviving spouse, but upon the surviving spouse's death, it goes to their 2 children. Okay? And that's one of the things that a trust is I think, a useful vehicle because, you know, one thing that can happen, and this happens really on a pretty regular basis, is that a typical estate plan is you leave everything to your surviving spouse. And today, people are living in their 70s and 80s. Alzheimer's is very common now, dementia. People are getting preyed upon. People are lonely. And so the purpose of a trust is to provide that if a couple has accumulated wealth during their marriage, that they want to provide for the spouse, but they want to make sure when the spouse passes, the surviving spouse passes away, those assets go to their children. They're not preyed upon, whether it be a second spouse. I had a situation, a 92-year-old had a 65-year-old girlfriend. The family was concerned. She came down from Michigan. She said, Dad's spending money on his girlfriend. And it's like, well, she went to the banker, the attorney, and the pastor, and we all said, well, Dad can do what he wants to. Okay. You know, and so, you know, there's some reality out there that we've had all kinds of situations that you hear about. So a trust is a useful tool to try to protect the asset. We just had a situation with a client whose father-in-law the mom passed away, and the lady that cleaned the house within 2 weeks had Dad married to the cleaning lady's mother within 2 months. And it took them 9 months to get the marriage annulled. It just got annulled last month here in Cincinnati. And assets have been depleted, and they're going after the assets. This stuff happens in Cincinnati. Okay? So these are tools. I think that the other thing I would emphasize as far as when we do estate planning, we want to make sure that the family is financially secure if either spouse dies or becomes disabled. So I think we try to tie financial planning into the overall estate plan. And so in that regard then, you know, there may be a need for life insurance and disability insurance. And when we do that, then there's probably a need maybe to have a trust. Okay? And I have that. I have a trust for my kids. We have a very low cost effective way for young couples. I say, look, I'll give you the trust I have for my kids, so it's just boilerplate, but you can at least have a trust. And that I say my kids are not going to win the lottery when I die. I mean, they're not going to just all of a sudden boom, you know. And if they're under 18, when they turn 18, they're entitled to the money. If you don't have a trust, you don't have a surviving spouse, and you're you know, leaving it to your children. So, you know, that becomes, to me, a very important issue, because you hear about all the time people that win the lottery go bankrupt, and people that are inheriting property, typically 90% of it's spent within the first year in inheritances. So those are some statistics, and that's why we use vehicles like a trust and an estate plan to provide that the assets are inherited, and then you can put the strings that you want to put on the property. In my trust for my kids, that when they were younger, they had no right to any money until they were 25. They had to go through college, and the trustee made discretionary distributions to them, and they had a third of 25, a third of 30, a third of 35. Well, now my kids are 30 and 33 almost. So now it's a third when I die, a third 5 years later, and a third after 10 years after my death. It allows them to inherit property, maybe blow the first third in the first 5 years, and hopefully they get smart, and then they got the other third, and then if they get smarter, maybe they'll be able to save the last third. Okay, that's the idea. Okay, it's a very common technique that's used. So again, I try to, work with my clients and advise you what I do for myself. It's the same advice that I'm giving you as what I do for myself. I do want to go to page 4 that had questions for business owners. So we talked about, do you have a succession plan in place? Do you have a buy-sell agreement in place? And that's important if you got non-family members involved in the business. And what is the buy-sell relative to death or disability? And what are the triggering events? Is it the death, disability, retirement, voluntarily termination of them, if they voluntarily quit working, if it's a non-family member? Sometimes business owners don't, say, hey, if you're working the business, fine, but if you leave the business, you're no longer an employee, then it would trigger a buyout, from that perspective. And then we talk about number 3, we talked about that. You have the right people in place to manage your business in the event of disability of the owner or key employee. And then is the legal structure in place? That's number 4, for the continuity of the operations in the event of the death or disability of the owner of the business. We talked about the power of attorney that's used, or whether or not you're a limited liability company, an LLC or corporation. How is the structure set up legally to provide for the succession of the management if there's a death or disability? And also, asset protection planning is a very important thing. And when I was a partner at Touche Ross and Deloitte, at the time I was married, and all the assets were in my spouse's name. Ask the partners that were at Arthur Andersen and Enron, who went bankrupt, whether or not they had done any asset protection. Okay? And so it's important, if you're a professional and you have any types of liability issues, one of the simplest things you can do to separate the liability is keep the assets in your spouse's name, and then you're out there, operating your business and whether professionally or however, and you have that risk out there, but at least you're able to protect some assets. The problem is you cannot transfer assets to your spouse. It's a fraudulent conveyance issue. So there's a fraudulent conveyance issue if you do it too late. In other words, oh my gosh, I'm going to get sued. Let me start making some transfers. Too late. So you have to do advanced planning at a time when there's no lawsuits pending. It's just prudent estate and asset protection planning. It's the simplest thing you can do. We also have some documents, too, that are a little bit more complicated for doctors and professionals, where we'll use a separate trust, and we'll hold the assets in trust in the spouse's name. And the professional who has, for liability purposes, will have basically a power of appointment upon their death to appoint those assets to their trust. So while the assets got asset protection while they're living, if they die, those assets go into a trust, are held for the benefit of their spouse and children, and so that that the money is going to be providing for your family the way you want it to be provided for. By the way, if your spouse dies and they've got all the assets, her trust goes in, you're the beneficiary of her trust, and there's a spendthrift clause that your creditors can't get to those assets. So you actually have some asset protection for the assets that you inherit from your spouse if she happened to die before you did. So it's a simple technique we use to try to get asset protection into an estate plan using trust. So that's another thing that some business owners are really concerned about and want to handle that issue. Moving along, if we go back to the outline to page 10, let's talk about business owners using a trust in their in an operating agreement in their estate plan. I have a client that's a business owner. I mentioned that basically the company was put in his trust. I mentioned that In his situation, the children were not in the business, and he wanted the key people in the company. He had people, even successor trustees, that they would be in charge of managing the trust as a trustee and making decisions relative to what happened to the company upon his death, or even upon his disability. They kick in. So it's a very good tool. In the real estate used in the business may also be in the trust and controlled during his lifetime. Now, in this particular situation, the profits were allocated and paid to the family members pursuant to trust provisions, and they were sharing equally. And we also emphasize, when we're doing a lot of estate planning and succession planning, that one of the things I'm very sensitive to is that family members working in the business are fairly compensated. And I say that because as a business owner, sometimes I've had to work evenings and weekends. Sometimes you have long weeks. And if you have a partner and you're one of several family members in a business, and one person is out there working 60-hour weeks and the other one's working 40, it'll build resentments if this person is not fairly compensated. Because think about that. You have 3 siblings owning a business, let's say, and the one person that's really working hard out there because they need to and they want the business to succeed, they're working, and so if they're not fairly compensated, the money that they should be getting as compensation is being split. They only get a third of that, and then whatever they get out of the third, the government takes a third to a half of it. It's very demotivating for a family member if they're not fairly compensated in the business. So I really emphasize that, to try to identify that. And the benchmark I use is try to evaluate who would you have to hire to replace the person in the business, and what would you have to pay them. That would be a good way of trying to evaluate what your compensation should be if you're trying to replace someone. If you do not want the trust to own your business, then the family members can receive the ownership interest personally. And they can, so they inherit it outright. So in that example, 3 children, they own a third of the company, a third, a third, a third. We have clients who are saying, well, wait a minute now. I have one person that's really my right-hand person that's helped me build the company. The other 2 siblings, one's out of the business and one's in the business, but they're driving the truck. So I want to give control to the person who has been running the company. So again, we can actually, what we'll do with that family business, we'll have voting units. Okay, and the voting units might not be that we would set it up so that the person who wants to have control, they might have all the voting units, or at least they'll have 60% or 70% of the voting units, whatever the owner wants. So that person has control of the company, but that all the non-voting units allows them to split the money equally, proportionally, a third, a third, a third. So the business, sometimes the problem we have with a business is, and business owners, the business and the real estate is most of the wealth of the company, of the estate. Most business owners, they've just pumped all their money into the business. So how do you do an equal division, a third, a third, a third, if you got 3 children in the business, okay? And so particularly the one child that's even not in the business, okay? So sometimes clients want to provide for a buyout. And sometimes it might be better for the owner to make that decision as to what the buyout's going to be. I just had a situation with a client that had a family restaurant franchise that she was running the past 20 years for her dad. She's got other siblings, and they're benefiting all of her work. She's tried to get fair compensation, but that's been an issue. And now she was buying it out. He's trying to do some advanced estate planning. So that was a good example where he did it during his lifetime. He transferred the ownership of the business to the sibling, to the child that was working in the business ahead of time, so that to avoid some of the valuation problems we got for the kids trying to split up the estate down the road when Dad passed away. Okay? So, there's all kinds of variations in this process, and it gets back to trying to work with the client, and I found every family business is different. I mean, there's no one way to do this. Absolutely not. Every situation is unique. Believe me, every business family is unique in the dynamics, okay? So it isn't like we can come out here and cookie cutter and say, okay, this is what you need to do. I have to listen. I have to, have my clients communicate to me what's important to them, what their issues are, and it gets back to who gets what and when. Those are the most 3 important questions in estate planning. Who, gets what and when. And the when, you might put some strings on some things. Valuing interest and splitting up the estate and trying to determine what's fair or equitable. The other thing you got to be careful of is that if you're inheriting a family business, state law for corporations provide that if you want to sell a company, merge a company, or get rid of it, it requires a 2/3 vote. Now you can have a shareholder agreement that says that a majority vote can control. So I'm always careful with business owners with that. If they're trying to have their family inherit the business, that you may have three in this example, three of his children, and the question becomes whether or not he's got to get in that example. It'd be at least 2/3 would have to agree, but he might want the one son who might give 51% to, that's been running the business, with voting stock control. So we would have a shareholder agreement that would dictate that all decisions would be made using a majority, maybe a 51% majority, and not a 2/3 vote for the sale or merger of a company. I think that we talked about death or disability of the owner, and having the operating agreement trying to identify, okay, who's going to be stepping in line and who's going to be making the decisions upon the disability of the owner. I think the valuation is always an issue in a family business. Scott in my office is accredited in business valuations, and he's worked with me with business owners. There's a lot of really good estate planning techniques that we should mention, that the federal estate law changed in 2013, that each person has $5.25 million they can transfer to their family estate tax-free. And then for a couple, it's $10.5 million. What they did when they changed the law, the estate tax rate is 40%, anything over that, but most people, they eliminated 75% of the estate tax returns would be filed. So from that perspective, there's really typically for most people, there is not a problem with estate taxes. But I had a family situation that had real estate and other business interest, that he had a $7 million estate, and the businesses made up around $5 million of it. Scott and I, we gifted that to his children in December of 2012. Scott did the valuation, and we got a $2 million discount. In doing that, we took $2 million out of his estate and saved $800,000 in estate taxes. He's going to have a $5 million estate, but we were able to get a discount because we used a limited liability company, and he gave up control of the assets and made the gifts to his children. And so there's some techniques that are out there to do some estate planning if you got a very large estate. I wanted to mention that. If anybody has a large estate, we're more than happy to work with those issues too. They're always interested in that. And I guess in wrapping up, there's also our questionnaire for married couples that we've included in the handout. This is a good tool to use if you're going to meet with your attorney, your tax financial advisor, to identify your estate planning objectives. And it asks the right questions so that when you go in, you can get your estate documents prepared by your counsel. But with that, we're kind of wrapping up the seminar here. I'm glad everyone was able to make it out in 0 degrees temperature this morning. Applaud you for that. Thank you. We got a raffle drawing here.
I'll just go over one question we did get was for Medicaid planning with the Roth IRA, because there are no minimum distributions, would the Roth have to be used for nursing home care? In Kentucky, no. You wouldn't even have to take out because there's no requirement to take out minimum distributions, you would not. But Ohio would require you to cash in the Roth to use it for nursing home care.
Okay, good question.
Any other questions?
Doesn't an operating agreement override state law on that?
It does. The state law says, unless otherwise provided by the shareholders, by the corporation, and then you do that through your shareholder agreement, operating agreement. They call it different things. It's the same thing.
Unlike the state.
Yeah, right. Exactly that. Okay.
Okay. Does everybody have their name in the drawing? All right. Phil, you pick it.
Okay, here we go. Ta-da. Here it is. Adam. There you go. All right, Adam. Very good. I guess as a final thing, we'll be here for questions afterwards. Also, as we talked with, it was in the seminar outline, each of you, if you want to meet with me individually for an hour at no charge to follow up with any questions you have, just contact me. I prefer my cell phone, as you find in my marketing materials. Clients call me on my cell phone, and half the time I answer. The other half the time I call back when I'm out of my meeting. So thanks for coming, and hope you enjoyed everything. And you'll be able to see it on YouTube if you want to come back and listen to it again if you missed something. Thank you.